Welcome to Popcorn Planet. I am Andy Signor, and I'm getting so frustrated at the culture war that's brewing due to this Amber Heard loss. A lot of people just can't handle it, and a lot of people are using the excuse that, well, she won the UK trial, so this shouldn't have even happened in the first place. Well, I want to thank so many of my subscribers who introduced me to Daniel here. The black belt barrister is here. Oh my God, I'm so honored. You could beat me up, and you're smarter. What an honor to have you on the show. But Daniel, you did a fantastic video that got sent to me by so many people, and you really broke down really eloquently and calmly just sort of how the UK trial really wasn't as fair, and Elaine and everybody out there saying that all the evidence was there and that this was a clear-cut case. You really were able to cut down pretty clearly why that wasn't the case. So thank you for being here. First of all, welcome. How are you doing today?
Great, thank you. Yes, it's a nice Sunday. So yeah, working as usual, but that's life of a barrister.
Well, actually, let's start there. What is a barrister? I called you barista before we even started showing my stupid Americanism. But can you clarify for people who are unfamiliar the difference? What is a barrister, like a lawyer in the UK? What's the difference?
Yeah, so we have a split profession. We have solicitors and barristers, and then lots of others like legal executives and so on. But very broadly speaking, a solicitor will generally prepare the case and file it with the court, and the barrister will go and represent the case in court. So it's the barrister you'll see with the wig and gown on the TV programs and on TV live courts and things like that. So
you're really in there dealing with it. So you know a lot about how these court cases work, how the judges work, and you have followed the UK case to sort of understand what happened there. Before we even get to the nitty gritty, do you feel like the UK case against Johnny was the verdict was fair?
Broadly, no, I don't. And there's a number of reasons for that, which I did cover in my video, which obviously you can link. But very broadly speaking, I feel it was the wrong defendants. I say defendants because there were two defendants in the UK trial, neither of which was Amber Heard. And there's a lot of discussion over the effective defendant, or the effective opponent, which ought to have been Amber Heard, because she, apart from Johnny, she was the center of this whole thing. And whilst the articles complained of in the UK was published by The Sun, written by Dan Wootton, the two defendants,
we'd say the word WB just so we all know what the headline is, but to help for sake of YouTube algorithms, before you say the word, exactly. This case was about The Sun. It wasn't about Amber Heard, and it was about the title calling Johnny Depp a WB, correct?
Yes, absolutely, exactly. And I wasn't going to say it, but you all know what I mean. So that was the article complained of, but neither of those defendants was Amber Heard. Now, the problem with that is we have very strict rules on disclosure. Disclosure, I think you call discovery, but it's broadly the same thing. It's tell us what documents you have that either support our case or undermine your case, and you have to tell each other what they are. Broadly, for everyone that doesn't fully follow legal procedure, what that is a principle of fairness. Everyone should have these documents to understand, well, what will help or hinder either party, and you've got to tell each other what those are. Now, for the UK case, Amber was not subject to those rules because she was not a party to the case. So there was an application by Johnny's lawyers to say, well, we should have disclosure from her as a third party. We call it third party disclosure to provide these documents. Now, whilst Elaine is going on interviews saying all of the evidence was heard in the UK, that's not true because there was an application for that evidence which was refused by the judge. So broadly speaking, I don't think that was fair.
So broadly speaking, she's not being truthful in that all the evidence was in and that this is a clear cut. Because the other thing I do know the difference between UK and US, this is one judge as opposed to a jury of multiple peers, which I imagine in your perspective, that's a harder thing to prove to a unanimous decision of multiple people versus one, no?
Absolutely. And I maintain, and I put this argument out, I think today in a video, that we maintain jury trials for certain things, mainly and notably for criminal trials. And I take the view that that's because if we're going to punish somebody, send them to prison and fine them and so on, we better be right. So we have a jury trial for that. If there's an inquest, which is investigating how somebody died and who's to blame, this is also heard by a jury. Defamation trials, by default, are not heard by a jury. But because it's phrased like that in our Defamation Act 2013, which codifies the current law on defamation, Section 11 provides that it's ordinarily not by a jury. which suggests that a court can order that it could have been heard by a jury. And I feel that with certainly a case of this magnitude, and the dollar or pound numbers involved and the reputation involved, this ought to have been heard by a jury. Because as you say, and as I've said in my video today, it's much more difficult to sway every member of a jury than a single judge. So it makes it more difficult.
I want to break down some of these things you mentioned in this fantastic video, which you can find here, and I'll link also in the description of the video. Go subscribe over there to Daniel's channel. But yeah, so just to getting in some of the things that you really focus on the credibility, and I think that's where a lot of us were having trouble too, of this judge in the verdict, and Judge Nichols really just decided to believe Amber on pretty much all of the charges, and seemed to just ignore and discredit all of Johnny's evidence, including officer testimony, a lot of stuff that was pretty much just ignored. And well, we believe, and I want to go through some of these examples you brought up, the biggest of which in the credibility issue is the fact that she was pretty much caught lying, given the Australia incident where they brought in the dogs and she documented false reports that she did. You do also make it clear she was guilty of and admitted to being guilty of this verdict, which again, huge credibility issue that she's now perjured herself and lied to the Homeland Security of Australia. That should mean something. And here's this letter where she writes, "I'm a proud lawful American," and says that this friend of hers, Savannah McMillan, was unlawfully working for her. But then it comes out through Kate James, who we met in the U.S. trial, well, that actually Kate James proved, well, no, she did, and she got paid. Whereas Amber justified it, well, she didn't have much money. I occasionally gave her money, payments to minimize the discomfort and embarrassment for her, blah, 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 blah. It plays very to what the Amber we saw on the stand, where she's always very quick to, well, blah, blah, blah. I'm going to justify this lie by just sort of prompting a little subtler lie.
Exactly.
It was a very telling moment that in the U.S., when we all saw it, no one bought it. But somehow this judge bought it. And what's really frustrating about it was that Kate James was discredited, correct?
Yeah, so in essence, it boiled down to the judge saying, well, she was fired, therefore she's not credible, because it's just as the judge described it as the rancor between them, the argument, the disagreement, the unease between them. Therefore, she's not credible. Now, personally, I don't buy that. And I don't think, in my experience, I don't think any other judge would have, if I were making that as an argument as a barrister, I don't think any other judge I've ever been before would have bought that either. And also, just going back one step with the money and her saying, well, sometimes she didn't have much money, so I gave her some money, but it wasn't to pay for her, services. I don't really buy that either, personally. And again, I don't think any judge I've been before would have bought that either. Right. If there was evidence and an admission on Amber's part that, yes, I gave her money, and you have another person saying, yes, she was working for her in the United States, one or another, you might be able to discount and say, well, I'll believe that bit or I'll believe that bit. But taken together, as we often say, multiple bits of evidence taken together usually make for a compelling story and compelling evidence. And so if those are taken together and believed, then the letter to Homeland Security was a lie. And, this just makes for a compelling story against her, in my view.
Right. And to add that, you said something in your video that really hit me too. The fact that the judge made it clear that any witness that comes into the court of law under oath is more compelling than anybody else. Yet therefore he did not accept Kate James's pretty amazing testimony, I think, and very telling testimony, even though it was under oath, basically calling Kate James a liar because she's disgruntled that she got fired, when there was evidence, clear evidence, that Amber had paid her. Again, just flagrant disregard to, well, I'm just going to ignore this to make a statement. Incredibly frustrating. Beyond that, then, so basically he said someone, right? Am I correct? Someone under oath he takes more seriously. Did not Judge Nichols say
yes,
that?
Well, it's more than that. This to me, this was a double standard, because on the one hand, the judge is saying, well, if someone comes, and this is a fair comment, but it's a double standard for these reasons. But the fair comment is, if a witness comes into court and swears an oath or an affirmation to tell the truth, the whole truth, nothing but the truth, then they are generally to be believed unless there is evidence to contradict what they say. But at the same time, the judge applied that to witnesses that were favorable to Amber. And obviously, Kate James and Johnny Depp's assistants said, well, they are loyal to him and she was fired by her, therefore I'll discount that. And again, I don't buy that. As I've said in my videos, I'm not quick to criticize a judge, but I don't buy that. It goes against what we would see as natural justice and witness evidence and witness testimony. And it goes against what the judge said. The judge did say in his judgment that if someone comes in under oath, they ought to be more believable.
Amber Heard herself wrote a letter to her attorneys, right? The only thing we're missing is evidence of the process being initiated, however, not completed. Therefore, the dogs weren't taken on the trip. That is obviously harder to prove since it involves documenting something that didn't happen. However, since I know we attempted to bring them at least once before the Australian trip, I can ask Kate to include that in her statement if that would be helpful. This is Miss Heard admitting to writing out loud, people. Should I ask Kate James to lie? And then it does, and it keeps getting worse. Kevin, what do you think? The person who did lie, could you possibly reach out for us? Meaning, do it for me so I don't get caught. Do you think you could get her to do it? And then Amber's own attorney saying, I don't know the relationship you have at this time. Again, proving that they had a disgruntled relationship, but seemingly were willing to ask her to perjure herself. Since you fired her, you have to be careful that she will cooperate and will not go public if you ask her not to be truthful. And how did the judge take this?
Well, absolutely. I mean, on the face of it, this should have been absolutely damning evidence because in the absence of anything else, the existence of these emails of her asking one person to lie, asking them to ask another person to lie, that, as I described in my video, somebody asking someone else to be dishonest is inherently in and of itself dishonest. If I asked you to lie for me about something and you go ahead and do that, or I'm asking you to ask someone else to do that, that reflects badly on me. That does reflect badly on my credibility. But ultimately, the bit that I really took issue with was the judge saying that because Kevin Murphy did lie, that made him less credible, and therefore it didn't impinge on Amber's credibility. And you can't have both ways. Because if she pressured him to lie and he lied, then you can't then say, well, because he lied, it's not her fault, it's his fault. And he said in his testimony that he refused to ask Kate James to lie. So again, you can't have it both ways. And I don't buy it.
It's just wild, the verdict here of just, well, they clearly were willing to lie, so therefore I can't trust their credibility, but I'm not going to doubt the credibility of the person asking them to lie. It really boggles one's mind. Mr. Murphy was prepared to give false evidence. This is not encouraging starting point for the submission that his evidence is now be believed. Yet Amber herself was asking him to lie. Her evidence is credible and fine. I do not accept that.
And just to say, on that one point, I could agree with that if that were taken in isolation and it didn't have an impact on everything else.
Sure.
If one person had made a dishonest statement, sure. Let's not discount the fact that if someone made a dishonest statement, sure, that their credibility is a little bit shot. But the person that pressured them to make it, or clearly, ostensibly, on the face of those emails, was asking them to make that statement, their credibility should be shot as well.
Well, and it says here, so the judge says, I do not accept Ms. Heard sought to pressurize Mr. Murphy into making a false statement into the proceedings. Yet, literally, we have it right here. Kevin, what do you think? Could you possibly reach out for us? Do you think you could get her to do it? I guess the debate of, is that the level of pressure? Feels like enough to me, Daniel, that she's clearly asking someone to potentially do her dirty work, no?
Well, it seems to a lot of people to be exactly that. It seems to be the pressure. It seems to be on the face of it. I mean, there's nothing really, in my view, there is nothing within this that counters that suggestion that she was putting this pressure to make this statement. There's no other reason for it, in my view.
But accordingly, the judge did not consider the allegations regarding either Miss James or Miss Murphy impinging on the credibility of Miss Heard. So therefore, discredited. We will continue to believe Amber. And then things, again, caught again, we're asking Kevin to procure these slightly altered health documents for their shots. Do we have a vet that we could grease? And Amber's justification for this was, well, that was Johnny's language. I didn't do it. That was Johnny. And the judge just accepted it.
Johnny, yeah.
The judge just accepted it.
Again, absolutely. And this is important because, again, in isolation, if this was the only thing and she said, well, that's Johnny's language, it's language that Johnny used. Now, as a side point, most couples will share phrases and language and words. And because they're a couple, they live with each other, they talk with each other. And so they might share that language anyway. But again, if this were taken in isolation and it was the one thing in question, and she said, well, that's Johnny's language, he asked me to do that, or he sent it, or he asked me to write it, whatever, in isolation, fine. You might say, yes, that might well have been him at the helm for that email, but only really if it's taken in isolation. When you take it with a whole series of other things, including, remember when she pleaded guilty to lying to the Australian authorities about importing the dogs, taken together.
It's an important one not to forget. I'm glad you keep reminding us because she admitted to pleading guilty to it, so she clearly did it. And all of these things together, yes, should amount to something.
It's a legal thing. When it's a bit like the behavior panel and the body language experts, and they're great guys. But they often say with any one facial expression, you can discount it. But when you've got 4 or 5 going together, it means something. And it's the same in law. If you've got one inconsistency, you can probably discount it. If you've got one slight dishonesty, you can probably discount it to some degree. But when you've got 4 or 5, even if there's question marks over all of them, you take them together and you think, well, on the balance of probabilities, which is what this case should have been decided, on the balance of probabilities, all these things taken together should have been a massive red flag. And remember, this should have been a difficult burden to overcome, even though it's on the balance of probabilities. But the credibility here, bearing in mind she was the center and not subject to the same disclosure, there are so many problems with this case.
Right. Again, she didn't have the same thing. This is the most egregious for me because, again, adding to your point, all of the inconsistencies on her credibility. Next, you point out the audio tapes. Now, I don't have to play the audio tapes. You guys have heard the audio tapes. Danielle plays some of the audio tapes and gets some more detail. But I just want to focus on how the judge reacted to said audio tapes. In my view, no great weight is to be put on these alleged admissions by Ms. Heard to aggressive behavior. Basically saying, and correct me if I'm wrong in misinterpreting this, but you say, because she wasn't under oath, the judge said, because she wasn't under oath, we can't take these recordings as true, as truthful as she would be in court, which to me is insanely absurd because if anything, I would think that these recordings might be more telling of how she actually behaves in private versus how she's clearly willing to lie under oath. What is your reaction to the judge's ruling that these tapes be admissible and it's not fair because she wasn't under oath during the recordings?
Well, this is the bit that I take the most issue with, and I'm glad that you do, and I think that a lot of other people do. And again, without being quick to criticize a judge, I think this is so far removed from judgments that I've come across before that this really concerned me. Because if we start from the premise that, yes, the judge is right in that if someone comes in on an oath to tell the truth, you should be able to trust them to tell the truth. But guess what? Sometimes some people lie. Otherwise, we wouldn't have criminal courts and people saying they didn't do something when they're found guilty, right? So that taken into account, the next best thing is a live contemporaneous recording, contemporaneous being at or around the same time. And in the case of the audio recordings, at the time, live recording of what happened is the best evidence as to what happened. That's why we have police walking around with body-worn cameras, which I'll come back to in a minute. But body-worn cameras, audio recordings, people take their phone out, start filming what happened. Why? Because no one can dispute that. You can see it happening, you can hear it happening. And the argument in this paragraph of the judgment was that because the excuse from Amber was that these audio recordings had a purpose, as the judge put it, a purpose or purposes different from simply conveying truthful information. therefore it was less reliable. Again, I don't buy it. This was a recording of what happened. It was an argument between them. She was belittling and ridiculing him for essentially complaining about being what sounds like being slapped around rather than punched with a closed fist. Now, I'm a martial artist. There's lots of different ways to hit somebody. You could punch somebody with a closed fist. You could do just as much damage with an open hand, with what we call a knife hand. I'm a 30-year martial arts veteran. I'm a sixth Dan. I've taught the army. I've taught martial arts for many, many years. So I can say this. I could be called as an expert witness to the court if necessary. Now, it doesn't matter whether it's a closed fist punch. And I've never mentioned this in my video, so this is exclusive for your video here, but I've never mentioned this before. But it doesn't matter if it's a closed fist. It could be an open fist. It can be a slap. It can be this, what we call a knife hand. All sorts of different things can be equally or more dangerous, more painful, more damaging than a closed fist. So I really take issue with this, not taking these audio recordings into account, because this was a live recording of what happened. They do very much sound like, in my opinion, for legal reasons, it's my opinion that these were admissions that she was starting the fight, she was hitting him, and she was the aggressor. And for them to be discounted, for me, is a serious problem in this judgment.
Oh, and also a serious problem because basically in defending Amber, he's acknowledging, well, she was lying on those tapes. Is the other thing that really bothers me, because
yes,
she's either lying on the oath or in the tapes, and the judge
that's the only other conclusion.
She's lying in the tapes, but I'm going to trust her on the stand, and it's just like.
and this is why many lawyers, and it might be a jump for many people, but this is why many lawyers have taken issue with this, because we as lawyers sometimes we have to draw inferences and we have to make assumptions. So we're given a set of facts, we can draw an inference from something, which means, well, if this and this, then it might follow that. Or we can make assumptions. So we can have a set of facts and say, well, if that happened, this must have happened beforehand. These are assumptions and inferences. So what you've just described there is a massive combination of assumptions and inferences drawn on, well, the assumption is she was lying, or as Amber put it, being sarcastic in the audio recording, and therefore she's being truthful on the stand. And I don't buy that the excuse that she was being sarcastic in all of the recording. There's a bit of it that you can hear she's being sarcastic, and the sarcasm is when she's ridiculing him for running away, for being, for being a wimp almost, or whatever. That's the sarcasm. In my view, that the sarcasm is not, it does not pertain to how she was hitting him. For me, in my opinion, the admissions were true. The admissions were that she was hitting him. And moreover, there's one phrase in particular from Johnny Depp on that recording that I find particularly convincing, when he genuinely sounds upset and he genuinely sounds worried and is conveying emotions and says, don't tell me what it feels like to be punched. In other words, if I feel like it's a punch, then it feels like it's a punch, whether it's an open hand, a closed hand, or whatever. So when he says those words, don't tell me what it feels like to be punched, in all my experience, not just as a barrister, but as a martial artist, as a person, as a parent, everything, to me, that was an honest statement. And these audio recordings should have been taken as such.
Yeah, I won't put you on the spot and ask you about the corruption that many fans are putting out there, saying like, oh, well, there's ties to Rupert Murdoch and the Sun, and who worked for the paper and who worked for the judge. But there are some fair questions that I implore you guys at home to go down the rabbit hole and look at yourself. Also, conveniently, this judge is now retired. He also ignored the appeal, which I know we have a lot to talk about. You talk about that in depth, but the appeal process, also not very fair, given that there was new things that came forward. Sort of quickly as we wrap up, were you surprised that the judge denied the appeal?
I'm not surprised at that, but because appeals are very difficult in the UK, and specifically England and Wales, because some people do comment that Scotland is slightly different. So let's just say England and Wales. But across the UK, appeals are difficult regardless. And ordinarily, they don't hear new evidence. So essentially what you could end up with in theory is a situation where you've got brand new evidence which you just didn't present to the court in the first instance. This new evidence might be a video recording of exactly what happened, and they could still refuse permission to appeal, even though this video now exists, because they didn't find it or didn't present it the first time round, because ordinarily the court won't receive new evidence and won't receive oral evidence. And so it's usually down to a question of error of law, error of procedure, and there must be a real prospect of success based on the premise that there's no new evidence. So it's a very difficult hurdle to overcome. And it's there for a reason. It's to stop every single person appealing. It's to require permission to appeal. And it's to require all parties to bring the evidence into court in the first instance. And this goes back to the original point, which is Amber was not a defendant in that trial, meaning she was not under the obligations for disclosure, or discovery. She didn't have to bring she didn't have to provide all of these documents or these evidence. And in the judge's words, it was, at her choice. And I think that's wrong, personally.
There's so much you can break down more. And I want to talk to you more. In fact, I'd love for you. I hope you will do more on that UK verdict. In fact, and if you're ever down, I would do a whole stream where we just read it all together in full form, long form, whatever you want. I'm here to help support it. In the meanwhile, whatever you would do, make sure you guys go support Black Belt Barrister over on YouTube. Throw him a subscribe. Check out his videos, especially check out the one we just discussed and the more coming forward as he really breaks down this UK verdict and more. Love your insights, sir. In fact, I'd love to talk more about could she get perjury charges? In fact, I don't want you to answer. I'm going to tape that with you at another point. So stay tuned. We will get Daniel back in here to discuss more about this case and so much more. Appreciate you being here, sir. Thank you so much. Great to meet you. I'm glad the fans connected us. Go subscribe there. And if you haven't subscribed here, subscribe to us both. Hit the bell for all alerts while you're at it. Smash that like button. Leave a comment below to help with the algorithm. And stay tuned for more coverage here on Popcorn Planet.